Hi everybody. In this tutorial I'm going to talk about a category of crimes, or what are categorised as criminal offences, a group of offences called strict liability. Now, a strict liability offence occurs where a defendant commits an unlawful act, and that act needs to be, in line with the usual principles, voluntary. Okay, so it must be something that hasn't been committed involuntarily, so where a defendant has no control over their actions. It must be committed voluntarily. It doesn't need to be committed willfully. There needs not to be, rather, any mens rea at all required. So no state of mind, no willfulness, no intent, no knowledge or belief, or even any recklessness is needed for one of these offences to be committed. It's interesting that they are technically referred to or treated as criminal offences, because what they actually are regulatory offences. They're in place to encourage high standards on businesses, companies, individuals, and they serve to protect the public. A really good example of a strict liability offence is one of drink driving. Could be referenced through the case of DPP and Harper. Drink driving as a crime requires a commission of the unlawful act, voluntarily, of course, driving a vehicle under the influence of alcohol. Similar crime could be of drugs as well. But there needs to be no intention to have done that. A court, in the main, is not really concerned with whether you intended to do that or not. I mean, there are defences available, limited for a crime of this nature, but there is no requirement on the prosecution to prove any state of mind in committing of this crime. Now, many of these offences are created by Parliament, so you would find them in legislation, but there are also many common law strict liability offences as well, and certainly through common law the courts have tried to clarify what we mean by these areas. Strict liability is a minefield. There are a huge number of different pieces of legislation, and if you were to study law at a higher level you would need to go into these in far more detail, but teaching at A-level standard, I like to keep it quite structured and simple, in the sense of being able to categorise these areas for you to identify what the main concerns of Parliament and the courts are. The key areas for strict liability, there are 5 main key areas that I'm going to put here on the screen for you. So the need to control pollution, so any waste or chemical disposal. Health and safety laws. So health and safety became a real agenda item for the government and Parliament in the 70s, and resulted in the passing of the Health and Safety Act, particularly in relation to workplaces and places open to the public. So food hygiene, protecting people from harmful substances, asbestos, etc., just became a real concern. Possession was a third category or area here. So possession of drugs or weapons. Again, simply being found in possession of drugs or weapons would create liability there. No need for any mens rea. Of course, these types of crimes, if they become more serious, so if you are suspected of supplying drugs, that's where mens rea may then be needed. So we, as courts, we refer to the legislation, first of all, to identify whether there is mens rea needed for a crime. It may not always be obvious that a crime is one of strict liability. There's no set piece of legislation or code that says these are all of the strict liability offences. A court would need to look at the law, and if there is no mens rea, then they could presume there will be no mens rea. But also, courts need to look at or consider the severity of the offence. If you are charged with possessing drugs and supplying drugs, it follows that there needs to be some kind of state of mind in supplying those drugs as well. So do they have intention to supply those drugs to others? Would be the necessary mens rea here. Okay. The fourth area is road safety. So again, one relating to safety of the public. If you look, there's a theme with all of these. This is all about public safety, really. Many road traffic offences that you would find under the Road Traffic Act would be of strict liability. So if your car is deemed not to be roadworthy, a police officer or prosecution would not be interested in your excuses for not being able to take that car to a garage. They have the power to enforce a penalty on you at the time. If you go to court, again, the unlawful act that you've committed would give rise to the liability. If you speed, there's no need to prove awareness of you speeding or not. It's simply you speeding that is the liability here, the unlawful act. Finally, there's an area of social concern. So the selling of alcohol and, of course, cigarettes. Now the age limit there has been raised. So selling of any alcohol and cigarettes to those under 18 is strictly illegal. So I've put here that this is a task. So if you look at the next slide, there are a number of different cases here. What I'd like you to do is just to pause this, please, and see if you can match these cases to the areas that I've just talked you through. So hopefully you've completed that task and identified that Alpha Cell and Woodward is a clear illustration of pollution. Crown and Howes in the middle is an illustration of possession of a weapon. And you see some of these you might think are quite unfair. And that's the thing with strict liability. It's about being aware that the state of mind and the belief of somebody is not an element for a court to consider. Harrow, London Borough Council against Shah and Shah would be a matter of social concern. And then you've got your food safety or health and safety areas, evidenced in Smedleys and Breed and Callow and Tilstone. And then finally, road safety in Bosher. Now, the selling of alcohol under social concern has been an area for debate, really. And there are two key cases that I want to draw your attention to, both cases that involve potential liability under the Licensing Act of 1872. So the first case, Cundy against Lecoq. So the defendant was convicted of selling alcohol to an intoxicated customer under the Licensing Act, even though they said that they were unaware of their state. So in the Licensing Act, any mens rea needed was silent. There was no mention of any mens rea. So the court decided there was no proof of any knowledge or belief needed. So they were strictly liable here and guilty. But we could contrast with the slightly later case of Sherris and Derutson, 1895, again a case of the Licensing Act, stating it's illegal to serve a police officer whilst on duty. In this particular case, a police officer removed his armband that signified him being on duty and was served alcohol as a result. So you could read about this case online. He was convicted at first instance of selling alcohol to this police officer, but he appealed, as is a right by law, and his conviction was actually quashed because although he had no knowledge of believing So although there was no knowledge required in believing that somebody was on or off duty, the court recognised that this was unfair given the officer's actions. The appeal court recognised it would be easy for a constable to say that he was off duty when asked, or even produce forged permission from a superior officer. And they recognised it really was unfair that on the defendant, given that the police officer had removed his armband before entering the public house. They deemed that it was only right the conviction be quashed. So that was quite an interesting case, really, because it seems to depart from the strict liability that we've been used to. Although, obviously, you need to know that there was no need for any mens rea to be proven. Rather, I think the appeal court may be identified with the unfairness of the conviction, given the specific set of circumstances. The test for determining whether something is a strict liability offence, if a court is unclear, comes from a case called Gammon against the Attorney General of Hong Kong. You can look these facts up online. They're not particularly going to set your world on fire. And what the outcome, or what this case says, is that mens rea will always be presumed in criminal cases. Go back to our lessons on principles of criminal liability, how we construct a criminal offence. A criminal offence is made up of both actus reus, the physical action of the crime, and of course the need to prove a link from that action to the result, if it is a result crime, the rules of causation being needed, but also the state of mind, the mental element of the mens rea of the crime also needs to be there as well. In the absence of an element, a defendant cannot be proven to be guilty. So mens rea will always be presumed. This is the starting point, the presumption in criminal cases, unless the statute says otherwise. So if the statute is silent, like the Licensing Act, then a court can, rightly so, presume that no mens rea is needed. Also, if the matter is one of social concern and a court believes that in upholding or maintaining high standards, a conviction will lead to greater vigilance in preventing commission of the offence in future, then that should also make an offence strict liability. So this is all about what is best for the public, really. This category of crimes or regulatory offences have developed in this way. So I want to just take a few minutes to go through a particular area of strict liability with you, of sex offences. Whilst not on your A-level specification particularly, it's an interesting and I think a socially important area that you need to be aware of. Previously, such sex offences have not required any mens rea for guilt to be established. So they have been defendants have been strictly liable, okay? And I'll take you through a couple of cases that illustrate how the courts deal with these crimes. So we'll start with the older case of Prince. Now, Prince, in 1875, was convicted under Section 55 of the Offences Against the Persons Act, if you can remember the year, 1861, of abducting an unmarried girl under the age of 16 without her father's consent. He believed, and that belief appeared to be reasonable, that she was 18. He appealed against his conviction. The court, reviewing his appeal, said, well, there's no mens rea mentioned in the Act for this section. So therefore, any belief that he had was no defence, even if that belief was reasonable. So his conviction was upheld. So you might feel that that is slightly unfair. The position then changed somewhat in the case of B against DPP, so B, seeking an appeal, and the Director of Public Prosecutions being involved. So this indicates, if you ever see Director of Public Prosecutions or an Attorney General, this always indicates a significant change in the law. These people running or defending an appeal, a prosecution, if you like. So this involved a boy, so B, aged 14, was charged with inciting a victim under the age of 14 to commit an act of gross indecency. So if you read the facts online, he was asking her to perform oral sex on him, or as he called it, a shiner. So she refused, obviously complained, and he was charged with this offence. He believed her to be over the age of 14. So same age as him, and that's what he maintained. Now, what the court maintained decided here on appeal, is that the greater the seriousness of the crime, so the more serious the crime, the more likely that mens rea will actually be needed, even if on the chance that a piece of legislation or an act is silent on that point. So his conviction was actually quashed in the end based on his reasonable belief. However, it's important to note that for liability in areas of sex offences, the law distinguishes between those crimes committed against victims under or over the age of 13 years old. If a defendant commits a crime against a sex crime against a victim under the age of 13, this is more likely to be a strict liability offence, even though it is of a more serious nature because that victim is younger. But it's absolutely impossible that a court would allow a defendant to argue that this victim, or they believe this victim to be older. Okay, so if you were interested in this area at all, in learning more, if you looked up the Sexual Offences Act 2003 from B and DPP, really launched a review into this area, and we have now a piece of legislation that covers this category of crimes. What you should also do is look up a case called Sweet against Parsley, 1970, because this case distinguished between what should be regarded as a strict liability crime, so regulatory, but also those crimes that are truly criminal and therefore require mens rea. The presumption will be the more serious the offence, the more truly criminal it is, and the need to prove mens rea would be applicable. Okay, so the final thing for me to say really is that, as with any crime or any offence in law, a defendant has the right to raise a defence. Now, defences for strict liability crimes are rare, but those defences available are only going to be those linked to the actus reus, because of course there is no mens rea applicable. So if there's no need to prove mens rea, in turn there's no need to discount the mens rea either. So you could try to raise duress, perhaps, so the act you've committed is not voluntary. It's going to be very difficult, because for no voluntary act you need to prove, or you need to show at least, or bring evidence to show that you were prevented from committing that act voluntarily. So that was a completely involuntary action. Automatism could be raised to show that you had no control over your physical actions, perhaps. A defence that can be used in relation to strict liability is one of due diligence. In other words, taking reasonable steps to prevent the offence. And due diligence is a more general term where, you know, for example, if you're buying something or you're buying a business, you should always carry out your checks first, and that's really what it's about. So, what steps have you taken to prevent the offending? Just note though, in Callow and Tilstone and Harrow, LBC and Shah, these defendants did not succeed in successfully raising due diligence, even though in Callow and Tilstone, the butcher had taken the carcass to the vet to be examined and make sure it's fit for purpose. That is what we could call due diligence, but he was not able or not successful in relying on that. And in the case of Shah, you know, these shop owners had provided training to their staff, and yet their staff still refused to follow the rules. And you could say there plenty of due diligence had been carried out, reasonable steps to prevent any offending had been taken, but these defendants were not successful. So a tricky area actually to escape. You could claim that you made a mistake, but of course it depends on the basis of that mistake. If that mistake is due to any intoxication, then that absolutely would not be available. And it's worth noting that Prince did not succeed in raising this defence. It really, therefore, appears that only truly criminal offences enable raising of defences for crimes. Okay, so that's the law in a nutshell. As I say, there is far more to it, but hopefully this gives you a good grounding, certainly for A-level standards. And what you'd be required to do for the OCR A-level specification is to apply your knowledge. So I'm going to show you, you've got a scenario here, scenario 1, scenario 2, and then scenario 3 and scenario 4. So what I would like you to do is to have a go at identifying how the laws that we've learnt about in this tutorial apply to these defendants. Which area is it of concern? What is the supporting case, and are these defendants going to be strictly liable? I hope you've enjoyed, and that's all from me. Thank you.